our speaker for the Supreme Court update. Um, Today we're going to hear from Lisa Soronen, who's the Executive Director of the State and Local Legal Center, or SLLC. In her role, she files amicus curiae briefs to the United States Supreme Court on behalf of members of the Big Seven in cases involving federalism. Ms. Soronen organizes moot courts for attorneys representing state and local government at the Supreme Court. She is also a resource to the Big Seven members on legal issues affecting state and local government, particularly at the Supreme Court level. Prior to joining SLLC, Lisa worked for the National School Boards Association, the Wisconsin Association of School Boards, and clerked for the Wisconsin Court of Appeals. She is a graduate of Central Michigan University and earned her law degree at the University of Wisconsin Law School. And she is always one of our most popular presenters. So enjoy. Thank you, Lisa.
So good morning, everyone. I want to start by introducing some special guests that I have with me. Out in the corner is my husband and my daughters, Sasha and Simone. So at my first meeting for this organization, I was pregnant with them in Madison, Wisconsin. And actually on that note, as I looked out at all of you today, there are so many faces that I don't recognize. So that's great. It's good to see new people involved in this organization. So I have a ton to talk about this morning. And oftentimes people come up to me afterwards and tell me that they've seen me at another NCSL meeting, which makes me think, oh, they've already heard all my content. Well, I've got news for you guys today. I have hot off the press, fresh information that no one has heard anything about yet. But actually, on a serious note, this term, or the last term I should say, was really significant in general. It was just a really big term with a lot of extraordinary cases, but it was particularly important for state legislatures. There are a lot of cases that require some changes or some thinking about what you should do with some of your state legislation. In fact, two of the biggest cases for states, the partisan gerrymandering case and the travel ban, I won't even talk about because I've got so much other content to talk about regarding cases that could impact the legislation that you all are working on. So what I'm going to talk about today, I'm going to provide an overview of the term. I'm going to talk about the cases from last term that affect state law, and there are many of them. I'm going to talk about Justice Kennedy and Judge Kavanaugh, soon to be Justice Kavanaugh. And I have just one slide of preview for next term. Normally I like to talk more about what's going to happen next term. There just isn't time for that today. So if you haven't spent all your time thinking about the Supreme Court in the last 3 weeks like I have, here is what the court looked like through the end of June. So we have, I should say, a 5-4 court with Justice Kennedy in the middle, hence the asterisk by his name, being our swing justice, more liberal on social issues, but still overall conservative justice. And as you know, we have big changes coming ahead. So like I said, this last term was really significant. We had big cases in the labor and employment space, immigration and law enforcement, tons of questions left unanswered by the Supreme Court. In gerrymandering, the famous case, and this was symbolically one justice's first term, Justice Gorsuch, and one justice's last after 30 years, Justice Kennedy. The court decided 72 cases. That's about typical. What was not typical is that the court is usually unanimous in about 50% of the cases. And I know this is kind of an old joke for those of you who heard me before. That's because 50% of the cases are so boring no one can remember them, but that's actually really true. This year we had about 40 cases, 9-0, which means there was less agreement on the court than there usually is. And another statistic sort of illustrates this well. Typically about 20% of the cases are 5-4. This time we had almost 30% of cases 5-4, lot of disagreement. So what happened? What was different? We had Justice Kennedy. I doubt in all 12 years that he was the swing justice without Justice O'Connor that he ever had sided with the right-leaning justices in all the 5-4 cases. This term he did that. He was a true conservative justice this term, which is not really typical of him. The court will hear or has now scheduled about 45 cases, which is typical. Justice Thomas wrote the most opinions, 31. I try to make it my goal every term not to read any of his opinions. I'm never successful. Justice Sotomayor is the most outspoken at oral argument. In fact, one of her favorite things to do, I just saw her do it this week, is she likes to ask a really sort of loaded, tense question right as the time is coming up. And the Chief Justice, I guess Rehnquist would cut you off mid-sentence when the time ran out. Chief Justice Roberts just doesn't have the heart to do that. And so she can put in her little digs as often as she wants. Sotomayor and Ginsburg had the most agreement. Alito and Sotomayor had the least agreement. I'm actually surprised Thomas isn't in there, but I think these numbers are all kind of at the margins. And interestingly, and this is the thing to look for the future, we have Chief Justice Roberts in the majority, more than Justice Kennedy. So we all can suspect he's going to be turned into our new swing justice. So the question is, how much is he really going to swing? Where Roberts and Kennedy were really different was that, I think in some ways they're both swing justices, but Kennedy would swing, and he said he didn't swing, the cases swung. Kennedy would swing in the controversial cases. Roberts more likely to be a swing justice in a less controversial case. And there were really only 3 close cases where he joined the liberals. So I wouldn't expect him to do much swinging, but he will be our new swing justice. So the first case I'm going to talk about is South Dakota versus Wayfair. I'm sure you're all familiar with it. And when your legislatures get back in session in January, this may be the first thing that you're going to end up working on. I'm going to provide a little bit of an overview of the case and then talk about what are the legislative issues that you're going to have to deal with when your legislatures get back in session in January. So this case, as you all know, the court held 5-4 that state and local governments can require vendors that have no in-state physical presence to collect sales tax. And for states, this is between an $8 and $33 billion deal a year. So the precedent on this is sort of interesting. It dates back from 1967. In 1967, and then again in 1992 in the Quill case, right before, and even this joke's getting a little old for me, right before Al Gore invented the internet, and right before Jeff Bezos got out of his garage selling books, the Supreme Court decided again in 1992, if you don't have a physical presence in the state can't come and force you to collect sales tax. Well, this all started changing in 2015. My organization, the State and Local Legal Center, filed an amicus brief in a case sort of tangentially involving the Quill Doctrine. We asked the court whether it would overturn or consider overturning the Quill case. And Justice Kennedy wrote a concurring opinion alone, saying famously, it would be great if the legal system would bring us a case to overturn the Quill case. So South Dakota rose to the occasion, which might surprise some people. South Dakota is a heavily Republican state. And remember, this is going to be perceived as raising taxes. You and I owed the taxes if Amazon didn't collect them. We just didn't pay them. But the taxes were already sort of owed. Yet people would look at this as an instance of the state legislature, or rather the state legislature is raising taxes. Anyway, it was a heavily Republican state that went ahead and did this. Why? Well, South Dakota does not have income tax, so it was highly dependent on sales tax. Also, for a long time, it was Oregon that had the most popular governor in the country. Then his girlfriend got into some trouble, and it became that Governor Dugard was the most popular governor in the United States. He was also a lame duck governor, so he could kind of do what he wanted. And he was able to get South Dakota to pass a law that said if you do $100,000 worth of sales in a state or 200 transactions, you have to start collecting sales tax. Now, this obviously violated the law, but it was intended to go to the Supreme Court. So before oral argument, we knew we had 3 votes to overturn the Quill decision. Justice Kennedy, he written the concurring opinion. Justice Gorsuch, while he was on the 10th Circuit, that case that I talked about that had gone to the Supreme Court on a kind of an unrelated issue, went back to the 10th Circuit. And Justice Gorsuch, then Judge Gorsuch, said, yeah, I think it's probably time for Quill to go. Justice Thomas in 2003 said, to me, the Karmas Clause is a lot like Santa Claus. Now my kids are grown, I can say this. I used to believe in it, but I don't believe in it anymore. So we knew we had Justice Thomas's vote, even though he'd actually been on the court in Quill in 1992. And interestingly, after oral argument, it was very clear we had Justice Ginsburg's vote. So people ask me all the time questions about her. The most recent question I got was, can an 84-year-old woman really work at full steam? And the answer is, I don't really know, but I can tell you this. I had never seen her as animated in all the years that I've gone to Supreme Court arguments. I've seen over 100. I had never seen her as animated. And part of that might be the fact that the cases where she might be animated, like an abortion case, Kagan and Sotomayor and Breyer are going to be animated. Well, none of her liberal friends were as animated. And she asked more questions. And she's not a assertive woman in terms of oral argument. She's generally very quiet. And I was never happier um, or more proud of Justice Ginsburg that day. She's also the justice most likely to cite to the SLC's work. So I have somewhat of a bias in favor of her, and probably some other biases as well. But after oral argument, there was no clear fifth vote. I left the argument feeling like someone hit me on the head with a frying pan. I wasn't expecting this to be 9-0, but I was expecting to win, and I was expecting there to be a clear fifth vote, and there just wasn't. So on the screen, you can read the reasons why the court decided to get rid of the Cole decision, but instead I'm going to tell you a story. So on Wayfair's website, it said, shop at Wayfair, you don't have to pay taxes. And I'm not kidding about this. In South Dakota's brief, they pointed that out, and then Wayfair, of course, took that off their website. That's really why I think the Supreme Court overturned the Quill decision. It was a big deal for the court to ignore stare decisis. And I'm going to take a moment on that for a second. Roberts Court is sort of famous for not overturning precedent. It's just not what they do. The last precedent I can remember the court overturning was, sit down for this, Citizens United, in Citizens United, which is years ago and a very, very big case. So this is a big deal. And the court, of course, overturned two precedent, which I'm going to talk about in a second. And I don't think, probably you guys in your job weren't regularly lobbying at the Hill, but I talked to a lot of groups that were always going to their congressman's office and saying, like, do something about this. So the court said it to all those reasons. Our economy has changed. You can be doing billions of dollars worth of business in someone's state but not have a physical presence. Why should that be the test? And of course, Congress could fix this rule. Congress chose not to. In oral argument, Justice Ginsburg was very outspoken about, this is a mess we made in the 60s. Let's clean it up now. Another thing that's quite remarkable is that the AGs filed an amicus brief in this case. And it's often the case, particularly in controversial cases, where the AGs file two briefs on either side. And to get 40 AGs, mind you, there's 5 states that don't have sales tax. So of course, they wouldn't join this brief. To get 41 states to agree to anything is really incredible. And this brief was mentioned in the court's opinion. So ultimately what happened was it was Justice Alito who provided the fifth vote. And I actually had a matrix of what justices I thought were most likely to provide the fifth vote. Justice Alito was not my first choice. I don't think he was even my second choice. I think he was my third choice. But this is what happened. And it became in some ways predictable. Justice Alito had been the leader on the Janus issue, the union dues issue, which I'm going to talk about in a second. Everyone knew he was going to write that opinion. And he did write that opinion a week later. I think he was worried about the hypocrisy factor, but in one case being willing to overturn precedent and write an opinion saying as much, and another case not being able to do it. So I think that's ultimately why he voted with us. I don't think it was because he had any real passion for the issue. The court basically said that it liked South Dakota's law for 3 reasons. One, it had that small business exception. So if you don't do $100,000 worth of goods or 200 transactions, you don't have to collect. South Dakota had promised up and down and put in their law that it would not collect retroactively. And then South Dakota was part of the Streamlined Sales and Use Tax Agreement, which I'm going to talk about in a second. The dissent was super interesting for a bunch of reasons. First, Justice Roberts wrote it, and he basically said, look, I agree Bellis Hess and Hill were wrong, but we built our economy around that. So why don't we just keep things sort of the way they are? And then he said also sort of famously, you came to us in 67 and you wanted this rule. You came to us in 92, you wanted this rule. Now you come to us 2018. Just because you keep on coming doesn't mean we should give it to you. So the Roe versus Wade defenders are like, whoa, whoa. Does this mean Justice Roberts is really against overturning precedent? Like, what are the implications of his statements? It's just sort of hard to say. Probably the favorite part of my opinion, or the favorite part for me about the opinion was, a lot of the concern raised in oral argument was, what about these small businesses? Isn't it going to be hard for them to collect? And Justice Roberts describes Justice Kennedy, who wrote the majority's analysis of this as breezy, like, oh, some tech companies are just going to come up with some software. It's not my problem, but someone will figure it out. And so that was sort of the response. So there's sort of two big questions for you guys in your roles. One, maybe less important, and the second one is more important. The first one is like, how much money is our state going to get? And GAO did a report in November, and it discussed a high and low estimate for how much your states are likely to collect, but only time will really tell. So the really big questions for all you guys as people who work on state legislation is, what are we as a legislative body going to do about this? So here are the five key components of what legislation is going to follow as a result of this, very likely in your state. So one thing is joining the Streamlined Sales and Use Tax Agreement. So I like telling the story because it's kind of funny, but it's also true. This is what the Streamlined Sales Tax Agreement does. They say, okay, a candy bar, is that a candy for tax purposes, or is that a cookie? And they decide how that gets taxed and how that's taxed in all the member states. My point is to say that the point of the Streamlined Sales and Use Tax Agreement is to simplify taxes and have sort of a national agreement about how tax structures work. And the Supreme Court, not once, but twice, said in its opinion, we like what South Dakota is doing because they're part of this agreement. About half of the states are part of the agreement. About half of the states are not part of the agreement. So there might be some pressure put on your state to join this agreement. On the slide, it's the red that are part of it and the blue that are not part of it. So, like I said, that might be something that your state considers doing. So then, most of your states, all of your states probably, should come up with some sort of like economic nexus requirement, like what South Dakota did, 100,000 transaction or $100,000 or 200 transactions. So you're going to have to come up with a test like that. And a couple states have done this so far, about 14. Some states also have notice and reporting requirements as another way of trying to make sure taxes are collected. I think that's going to go away. I think all we're going to see going forward is economic nexus. So a lot of states haven't done their economic nexus yet, but you will be doing that. So another big issue is this marketplace. So you're Amazon and you sell products that are Amazon products, or you sell products where you just create a marketplace. Like you're just sort of allowing the seller to sell on your website. eBay provides another example. Amazon, while collecting, is collecting for Amazon products. It's not necessarily collecting for those marketplace products. So a number of states, and not very many, have passed laws, the ones in red, that say, if you're operating a marketplace, you will now be collecting for the people participating in your marketplace. This provides some of that help for small businesses who are just selling little things on Etsy, etc. So a big issue also is, when is your enforcement date? We have 19 states right now that still haven't taken any action. That's largely because their state legislatures haven't met, or they might have too complicated of tax systems to implement all of this. So those are the dates. The other thing is, what threshold is your state legislature going to pick for the small business exception? Most states have gone with 100,000 or 200 transactions. Some states have higher thresholds, but that's another decision that your legislature is going to have to make. So all this to say that this is a big issue that you're going to work on when your legislatures get back in January, if you haven't already done this. A roadmap has largely been created for you by the Supreme Court and by other states that have already been involved in making decisions. So it's maybe more of a matter of getting it done than worrying about what the details are, but that is something that you guys will have to think about. So Janus versus AFSCME is the second case where the Supreme Court overturned precedent. And this case is a really big deal, and it was overshadowed, I think, largely by the travel ban and by Justice Kennedy's retirement. And so there's a state statute implication of this case that I think is lost on a lot of people. To be frank with you, it was lost on me until I'd given a presentation at NCSL and I had a union member write to me and explain exactly why this implicates state statutes. So it is state statutes that allow, or allowed I should say, union and management to have what's called fair share provisions, which were provisions that if you didn't want to join the union, you didn't have to, that was fine, but you had to pay almost all of the union dues. This is true in about half of the United States. State legislatures have passed these laws allowing management and the union to say, you don't want to join the union, fine, you don't have to, but you have to pay most of the dues. This decision, or the old decision, was called Abood, and the Supreme Court struck it down. That was the 1977 rule that made this practice okay. So these are the states in blue are the right-to-work states that didn't have fair share provisions. Gray, Midwest, West Coast, East Coast. where these fair share provisions existed. So for those of you who aren't that familiar with it and don't have this in your state, if you just sort of think about this intuitively, like why should you have to pay to be in an organization that you don't want to join, right? That's the sort of argument. Like why we have a First Amendment that says you can freely associate with whoever you want to associate with. That was the argument. On the flip side, the union has to represent anyone that can possibly be a member, right? So the idea was why should you be a free rider? Why should you get the benefits of the union negotiating and you refuse to pay? So the court basically said, this guy in this case, his name was Mark Janis. He was in Illinois. He was like a child support specialist. He said, this guy doesn't want to be a free rider. He doesn't want to be a part of any of the union negotiations. He doesn't want to get the benefits of the union. He just wants nothing to do with the union. He isn't a free rider. He's someone who's sort of like forced to go along with this one he doesn't want to. So the court, again, had to analyze stare decisis. Was it willing to get rid of precedent? The court said yes. The strongest factor, of course, for the unions was reliance. I mean, unions have been relying on this 1977 precedent and have gotten a ton of money as a result. The court said, reliance, it's just not enough. So for state legislatures, what do you have to do? Well, if you had these fair share statutes, you have to take them off the books and or not enforce them. The other thing that the court struck down was opt-out laws. So this is the idea that you would automatically be in the union unless you contacted the union and said you wanted to get out. Unions love doing this because no one would read the form saying, if you want to get out, contact us. So everyone would end up being in the union. The court also struck those statutes down. So if you have those on the books, you have to sort of take them out. Some states have responded, Hawaii in particular, by doing things to protect unions, like, for example, expanding the class of people that can be a part of a union. So the fallout, I think, is fairly significant. This case was considered the Citizens United of collective bargaining. It obviously guaranteed significant funding to unions that they now won't necessarily get. And this is also a loss for state sovereignty. Like I said, these fair share provisions were a function of state law. And this is where you see the right sort of, that tends to be more, pro-states' rights, pro-states doing what they want, being against a provision that gave states more ability to be flexible and have more freedom with how they organize their labor. And for those of you who follow the court carefully, there's been a lot of talk about the Supreme Court weaponizing the First Amendment. This is where that quote comes from. It was Justice Kagan. And, I think there's probably some truth to it. So the implications are that the unions in your state are going to get less funding because if people don't have to pay for a union they don't want to be a member of, they're probably not going to. So that's the likely impact that we're going to see of this. The other thing is there's a bunch of litigation like following all of this, and the litigation focuses on can people go back and say, I want the last 3 union dues that I paid that I didn't want to pay. Can I have those back? So there's litigation all over the United States on this. The next case that's likely going to come to the Supreme Court is a challenge to the union as the exclusive bargaining representative. So one of the pillars of unionization, like I said, was fair share. Another one is the idea that if I'm in a union, I'm represented just by the union. Like there can't be 10 unions trying to represent me because that would kind of create chaos. And so if you think about it, if the court says, well, you shouldn't have to pay for a union you don't want to be in, why should you have to be in a union you don't want to be in if there could be another union? And I think that there's a possibility that the Supreme Court will strike down that precedent as well. Probably many of you have the one union as an exclusive bargaining representative as part of your statute. So that's another interesting case. And like I said, it involved overturning precedent. Murphy versus NCAA may also lead to some state legislation in your state. It hasn't already on sports betting. So in this case, the Supreme Court struck down the Professional and Amateur Sports Protection Act as unconstitutional. This act prohibited states from authorizing sports gambling. Prohibited states from authorizing sports gambling. The court said it violated the 10th Amendment's anti-commandeering case. It was a 6-3 decision, formerly the Christie case, that came out of New Jersey. The background is kind of this. Atlantic City was struggling, and it wanted to have sports gambling. But the PASPA said it couldn't have sports gambling. The state couldn't authorize it. So Chris Christie thought, aha, what if PASPA is unconstitutional? Then I can have my sports gambling. So that's how the case came up. So for even the lawyers in the room, anti-commandeering is a pretty arcane doctrine. Even Justice Alito, an arcane person himself, was willing to admit that. But he said, simply put, the anti-commandeering means that the states lack the power to order or to issue orders to states directly. And this is great, the language in bold. He said, basically, what you have in this case is PASPA becomes sort of like a super state legislator. PASPA is this super state legislator that goes into state chambers and says, states, you cannot authorize sports gambling. And that's kind of how he describes it. And it's the idea that the federal government has come in and told your state legislature you cannot do something. The court said that's just not okay. This case is considered a really big deal because the court had only twice before said something was anti-commandeering. Only 2 times. The other thing is this. In the other cases, state legislatures were required to do something. In one of the cases, they had to accept nuclear waste. In another case, they had to do background checks for the federal government. Here, the states didn't have to do anything except not pass laws allowing gambling. The court said basically whether it's a prohibition or whether it's forcing the states to do something or forcing the states not to do something, it's all the same. It's all anti-commandeering. And what's interesting about the dissent in this case is that the dissent didn't even dispute the fact that there was commandeering in this case. What the dissent said was, why are we striking the whole law down? Why can't we just carve out little pieces of it? So the impact, of course, for all of you is this. Your state legislatures might want to authorize sports gambling. In fact, some of you already have. And there were 19 states last term that had active sports betting legislation. And I have on the screen the states that have already passed legislation. Connecticut is in italics because this is true fake news, guys. I'm not making this up. Connecticut has, I guess, not passed sports betting, but there's all these articles that indicate it has. So someone from Connecticut could correct me if I'm wrong about my fake news. But I just had to include that because I thought it was sort of interesting. So I love telling this story because I don't know anything about gambling, and I can sort of make myself seem like I look like gambling when I tell it. So I'm going to do that. So the important point for all of you as you deal with your state legislatures to know is this. Sports betting is not a get-rich-quick scheme. And I'm going to sort of explain how. And this came from the Nevada gambling guru. He said, okay, here's the deal in Nevada. So our total tax collections in Nevada for all of gambling, $875 million. That's a ton of money. Now look at this. Total tax collections for sports gambling, $16.6 million. I should say Nevada was accepted from PASPA. It could do sports gambling. So you see, they're making no money in Nevada on sports gambling. Why? This is where it gets fun. Okay, there's the handle and the hold. The handle is all the money that is gambled, right? All the money that's put in the sports book. The hold is the profit. Running a sports betting book is like running a grocery store. Your hold, your profits, are like 4%, 5%, 5.1% in Nevada. So what Nevada does is it taxes that handle, taxes the profits. But remember, there hardly are any profits. So if you were to tax the handle, maybe you can make some money. But if you only tax the profits, there just aren't that many profits to be had. So in Vegas, they say sports gambling is an amenity. Really, you're here to see Celine Dion, or let's be honest, I would be there to see Celine Dion. And if you make a sports bet or you have a hamburger, great. But it's just kind of considered an amenity. So for states that really want to get into this, I would say they should be cautious about it because it doesn't necessarily generate a lot of money. So another reason why Murphy's gotten attention is that people have wondered, are there other areas where the Congress has said states cannot act? You as a state legislature cannot act. On the screen, I have some suggestions. What people have said, these are other places where the federal government has told states, you as a state cannot act. As far as I know, there's no active litigation on any of these, but I do suspect PASPA was not a unique statute in the fact that it prevented state legislatures from doing stuff. But it was a great case. It was a great decision for people who work on state legislatures because the court really talked about the state legislative role. So Houston I can never remember how to say it, is another one of those cases that could impact your state legislature and could lead it to new state legislation in your state. So this case involves, to be frank, throwing people off the voter rolls. And basically, Ohio had a process of throwing people off the voter rolls that went like this. The first thing they would do, and this is important, is they would go and look and see who did the change of address card, right? But most people don't do that, right? So then their process was, we'll get people off the voter rolls by, if they don't vote in an election, we'll send them a notice. And we'll say, hey, do you still live there? If they don't respond to the notice, we'll let them vote 2 more times in 2 federal election cycles. If they don't vote, they get thrown off the rolls. So the question was, did this violate the National Voter Registration Act? So this act says that a state program shall not result in the removal of persons by reason of failure to vote. So the argument was, well, if I don't vote 3 times and I'm kicked off the rolls, then I'm being removed by reason of failure to vote. But the statute goes on to say in another place, you can't be removed solely for reasons of failure to vote. The argument that Ohio made was, we're not kicking you off solely because you didn't vote. We're kicking you off because you didn't respond to a notice and then you didn't vote 2 more times. And that's the argument that the Supreme Court ultimately bought. It said, look, the word is solely. You didn't respond to a notice, and then you didn't vote, so it's not solely. So this case is a big deal because it involves voting. It involves voting in Ohio. It involves people getting tossed from the voter rolls. And of course, about 12 states use this process, and now all 50 states can use this process if they want to remove people from the voter rolls in this way. This case was totally seen as political, and I just have to say this too. It came out in early June, and all the reporters and all the Supreme Court watchers were waiting for more exciting cases. And when this case came out, it didn't come out on a day where there were any other big cases. So it got, I think, more news media coverage than it normally would because it wasn't competing in the Supreme Court space. The case is absolutely seen as political. Justice Alito was like, nope, I stuck to the statute. It used the word solely. They're not being kicked off for solely. That's the end of the case. Justice Sotomayor was like, give me a break. The NVR way was to avoid poor people and minorities getting kicked off the rolls. This is exactly what's going to happen. The decision in the mainstream media was seen as political. I love this CNN headline. You had President Trump tweeting, this is like the best thing since sliced bread. So the case was seen as absolutely political. I have to tell you guys this. In my years at the SLC, in almost 7 years now, we filed an amicus brief, and all the groups that I work with, except NGA, the governors, joined it. I think this is the most controversial case we ever filed a brief in, because we avoid the really, really hot button issues. And NCSL's process, it's very hard to get NCSL to join a brief, and NCSL did. And I think the perception that I have, and maybe just because I want to feel better about this case, is that this case is really about good government. There are tons of local governments, Philadelphia actually being one, who are being sued for having people on the voter rolls who didn't belong there. I mean, it was like every dead person and their brother was still on the voter rolls in Pennsylvania. My point is this. There has to be some process other than the post office process, which most people don't do, to get people off the rolls, right? We can agree to that. But what would the process be? If not this process, then what process? And so, like I said, we saw this as a good governance case. I hope it's the case that political parties don't use this to throw people off the voter rolls. But here I have the statute, or here I have you can't read it, but I have the states that had the Ohio process and had a similar process. So about half the states didn't. So now it may be that your state legislatures, now that they know this process does not violate federal law, may want to use this process. So I would expect to see something on it. So the Masterpiece Cake case, oh my, what a case this one was. So I don't know if I've told you guys this story, and there are a lot of new people, and it's a story sort of worth telling if I've already told it anyway. So the Heritage Foundation, which is a right-leaning organization, has a meeting every year where they invite Supreme Court press members and other interested people, and it's a closed-door meeting. So I'm not allowed to talk about like what happened in the meeting, and I'm not really going to tell you what happened in the meeting, but I'll tell you one little story. And so last year I went to this meeting about this time, and there were all these things on the court docket: the partisan gerrymandering case, the travel ban. I mean, it couldn't have looked like a bigger Supreme Court term. And all people wanted to talk about was the cake case. This case involving these 2 gay men who wanted to get married and wanted to have a wedding cake from this particular cake vendor who would not make it out of religious reasons. So that's a sort of like bottom line of what happened in the case, or that was the bottom line issue of the case. The cake maker said, look, I have a First Amendment right to not make this case or make this cake. This would violate my religious beliefs, my First Amendment free speech beliefs, my First Amendment freedom of religion beliefs. And the gay couple said, That's all well and good, but Colorado has a public accommodations law, just like all 50 states do. But our public accommodations law in Colorado protects on the basis of sexual orientation. So you have to serve us. If this is an all-comer state, you have to serve us cake. That was what was at tension in the case. What the Supreme Court did, and this is kind of an illustration of what Justice Kennedy kind of did over and over and over again in the Supreme Court term, so I'm not going to talk about a lot of the cases where he did it, was he wrote the opinion and he basically sort of punted. He did not decide whether the cake baker had to make the cake. He did not decide whether the cake maker's rights were violated by not making the cake or by being forced to make the cake. Instead, what he said was the cake maker was subjected to religious bias. And the bias was when he went before the Colorado Civil Rights Commission. So what happened was the Colorado Civil Rights Commission was the first administrative layer to hear this case. And one commissioner basically said, like your religious arguments, it's nonsense. Religion's been used over and over again to discriminate against people. Look at the Holocaust. And Justice Kennedy said, give me a break. Like, this commissioner disparaged this guy's religion. He equated it with hate and all sorts of other things that are not true of his religious beliefs. And the court basically said, cake maker wins because he was subjected to discrimination. But we're not going to say anything else about whether whose rights were violated or how big the First Amendment is in this case or how big the public accommodation statute is. And in my opinion, for the lawyers in the room, and I know you're not all lawyers, I think the court totally wimped out. And this is going to be a little bit of a technical legal thing, and the dissent got into this. So the Supreme Court reviews decisions de novo. That means of the new, as if no one has ever looked at the case before. That's how the Supreme Court looks at cases. And so the argument that the dissent made was like, look, what the Colorado Civil Rights Commission said, who cares? What the lower court said, who cares? We're the Supreme Court. We get to decide what these laws mean. We don't have to worry about what anyone else said. I agree with that view, but that was not the view that prevailed. So what happened in this case was Justice Kennedy picked the outcome he could live with. And I'll try to do this, but I don't know if I can quite. I've done it a few times. It's hard to sort of pull off. So Justice is from the oral argument. Justice Kennedy talking to the lawyer from Colorado, and he says, okay, this commissioner said all these nasty things. Did he ever disavow those statements? And the lawyer said no. Well, did other commissioners disavow the statements? No. And then Justice Kennedy asked the lawyer, do you disavow the statements? And the lawyer's like, look, I never would have told my client to say those horrible things about religion. And the Justice Kennedy said, right now, do you disavow this statement? And the lawyer's like, yes, fine, I disavow it. But the point was like, this got under his craw. I mean, he was really mad about this. I think there's something bigger here, which I've talked about in the past, which is the idea that for Justice Kennedy, I mean, this case was really personal. I mean, he cares a lot about gay rights. He cares a lot about states' rights. He cares a lot about religious freedom. And I think he didn't really know what to do in this case, and he knew he wouldn't be on the court to further define what the rules might be, and I think that explains part of his punting. Now, what's interesting, for those of you who watched the Kavanaugh hearings, and I mean the first Kavanaugh hearing, Kavanaugh talked about this case at length during them, and he cited the language that I have in bold. So people, if you read the opinion, there's a lot of stuff on how great religion is and how no one should be discriminated on the basis of it. And there's a lot of stuff on, gay people should be protected and we shouldn't live in a society where they're excluded. And a lot of people, including apparently Judge Kavanaugh, believe that the enduring language from this opinion is that, in general, we as a society don't exclude gay people anymore. That's just not what we do. And you'll be curious to see how this all plays out. There are other petitions, there are other cases. So, the reality for all of you as people who work on state legislation is that this doesn't directly impact your public accommodation statutes. A number of you come from states that protect sexual orientation. More of your states may want to do that. But this case doesn't make any sort of statement on how big or how small that protection is, because the court effectively decided nothing in the case. So that's that case. Minnesota Voters Alliance versus Mansky is arguably my favorite case from the term. And it is my favorite case because when the court accepted it, I knew it was a loser. I knew there was absolutely no chance Minnesota could win this case. And we wrote our amicus brief in the hope that Minnesota would lose really, really well. And Minnesota did. The Supreme Court wrote an opinion that made me smile and made me happy. And it was a complete and total loss for Minnesota. But it could have been so much bigger and so much worse. And it's like one of those odd illustrations of the value of an amicus brief. There are some cases you can never win, that you shouldn't win. But it's all sometimes about sort of reining in your losses. And this case is just a brilliant illustration of this. So Minnesota bans all or a confusing body of political apparel at polling places. That's what Minnesota did. And the Supreme Court ruled 7-2 that states can regulate campaign-related apparel at the polling place. So they can't ban all political apparel, but they can regulate some campaign-related apparel. So where's the line? I have absolutely no idea. But I do recommend that you read this case if your state does regulate campaign-related speech. And so here's the deal. Like, you can kind of imagine the facts of this case. This guy wore a bunch of Tea Party stuff to the polling place. He was told he had to turn his shirt inside out, which I think that he did. But he said, look, the statute is overly broad. And the court agreed that it was overly broad. The court said, look, political speech, it's such a big category. We can't tell what's in or what's out. The statute doesn't define political. And if it was what candidates said, like in a campaign speech or something, your average poll worker is 80 years old. How are they going to remember? And I'm not kidding about this. How are they going to remember like every statement or every topic that was covered in a campaign? Like, that's impossible. And the court also said, like, if political is like an organization takes a position on political issues. One of the Boy Scout leader comes in with a uniform, and like the Boy Scouts arguably take political positions. Then he's got to turn his uniform inside out. I mean, the problem, I think, from the court's perspective was, like I said, the political was so broad and it wasn't defined. And they liked campaign-related because that was more narrow. Campaign-related can have problems as well. What the court did that was what was interesting, which is something they rarely do, and this is very much a Justice Roberts word, lucid. Justice Roberts said, look, I'm not going to say whether or not the California statute or the Texas statute are constitutional, but I'm going to say they're a whole lot better than Minnesota statute. So those are kind of examples of what the court thought was more okay. So the Supreme Court, there was a dissenting opinion that basically said, we don't know what the statute means. You should just send it back to the lower court to sort of figure out what it actually means. And the court cited to the SLLC's amicus brief a couple times in the dissent. And basically our brief said, you know, there really are problems at the polls. I mean, really crazy things happen in polling places, especially with people who have to wait in line for 12 hours. And these regulations aren't that bad. So these are the state statutes that do not prohibit political apparel or campaign apparel at the polling place. If you are from a state that is not on this screen, I highly recommend that you look over your statute and compare it to the Supreme Court's opinion. You're not going to know exactly what to do. I mean, there isn't that clear of guidance, but I think, you know, you kind of have to ask yourself, is our statute more like the Minnesota statute that got struck down, or maybe more like one of these two statutes? I'm giving a presentation in, oh man, it might be Kansas. And I looked at their statute and I thought it was fine, you know. So it may, but I think like if you, like I said, if you're in one of the states that bans apparel or regulates in some way, you've got to take a look as a result of this decision. So the next case is another very interesting one involving. Okay, I've totally changed how I've talked about this case. So I'm just to see if it works here. Okay. Crisis pregnancy clinics. They don't offer abortions. But what they do have, this came up in oral argument, and it was non-record information, and Justice Sotomayor brought it up, and I thought Justice Roberts was going to pop out of his seat and try to silence her. So like I said, crisis pregnancy centers don't offer abortions, but what they do is they have women on their websites in white coats. And so California was annoyed about this. They felt like we've got a ton of these crisis pregnancy centers, and they were worried that people were going to them thinking they could get abortions when they could not, in fact, get abortions. And like I said, there are over 1,000 more of these crisis pregnancy centers in the United States than abortion clinics. So what California did was it said this: if you are a licensed clinic, you are going to disclose that you don't offer abortions. You're going to disclose the fact that people can get state paid for abortions, and you're going to do it every time in 14 languages. And I'm not kidding about that. If you were an unlicensed clinic, you had to disclose the fact that you were unlicensed. So this should be an easy case for the Supreme Court, right? For those of you who are familiar with Reed versus Town of Gilbert, If you have a content-based restriction, it's subject to strict scrutiny and it's basically going to get struck down. Clearly, this is a content-based restriction. If you're a crisis pregnancy clinic, you have to say X. Couldn't be clearer that it's a content-based restriction. But this is where concurring opinions really get wild. In 1985, Justice Wright had written a concurrence saying, I think there's this thing called professional speech. And I think professional speech should receive less First Amendment protection, maybe even no First Amendment protection at all. And lower courts have sort of debated the merits of professional speech in the context of conversion therapy, physicians asking questions about gun ownership. And so the Ninth Circuit said, yep, we think this is professional speech. We think that California has more authority to regulate this kind of speech than they would other kind of speech because it's professional speech. The Supreme Court disagreed. It basically said, nope, we don't have a professional speech doctrine. We've never done that. Justice Wyatt was just sort of on his own tangent. So you can just sort of ignore that. So you may say, our state statute or our state legislature has never adopted a pregnancy clinic statute. So why should I worry about this? Only Illinois and Hawaii have had similar statutes. New York City, Baltimore, a couple other places have adopted them. Justice Breyer wrote a dissenting opinion saying, look, state and local governments have tons of notices that are content-based, like you have to wash your hands if you work at a restaurant. If you are a landlord, you have to say the following things to your tenant. And these are completely content-based, things that we make people do as state and local governments. Do all those things, does strict scrutiny apply to all those things? Does it really apply to the fact that a restaurant has to tell people to wash their hands? And Justice Breyer is kind of like, that's crazy. Like, we should have strict scrutiny applying to all these sort of various boring, benign health and safety regulations. And so I think that's something for the court to work out in the future. The other thing is a number of your state legislatures have conversion therapy bans. So conversion therapy is telling a gay person, I can't help you through therapy, not be gay anymore. A lot of state legislatures regulate these for minors. These now may be in trouble as a result of this decision. What also may be in trouble, though, is a couple state legislatures who require doctors to show women pictures of fetuses before they have abortions. Those are, again, content-based regulations. And the other thing that's gotten a lot of trouble in the Fourth Circuit is licensing regulations for people who speak for a living, tour guides and fortune tellers. Those are also likely to be struck down as unconstitutional. So this case, there's more to it than just crisis pregnancy centers. And I'm going to end in talking about this case by talking about what Justice Kennedy had to say about it. He said, so the California state legislature congratulated itself on being so forward-thinking by making these crisis pregnancy centers say we don't have abortions. He said, there's nothing forward-thinking about telling an organization that dislikes abortion that they have to talk about abortion and where you can get one. He said, that's not forward-thinking at all. That's the government imposing its views on a private organization, which just isn't okay. That theme I'm going to get back to later on in the presentation as I sort of wrap everything together. So Byrd versus the United States, I'm trying to think if there's ever been a case that I can think of that's like this. And it's come up before, but I can't think of another context. The Supreme Court issues a ruling in this case, right? But how your legislature treats, what I mean more specifically is whether your legislature criminalizes someone driving a rental car when they don't have their name on the agreement impacts the result of the Supreme Court case. I know that's kind of a lot to understand, so let me explain what happened in the case. So basically, there had been a big circuit split about this. You're a rental car, or you drive a rental car, but your name isn't on the agreement. And you're pulled over. Do you have an expectation of privacy in that rental car, even though your name isn't on the agreement? The court said unanimously, yes, you have an expectation of privacy. Why? The court said, well, in part, think about it. Like, if you were driving that rental car, your name wasn't on the agreement, and someone tried to carjack you, you could throw that person out of the car, right? It wouldn't matter whether your name is on the rental agreement. Like, they're trying to steal the car you're driving. The court said, yeah, you have some expectation of privacy in a car you're driving, regardless of whether your name is on the rental agreement or not. But the court said, if you were unlawfully driving that rental car without your name on the agreement, then you have no expectation of privacy. But the court said, we don't know whether the 50 states say that if you are driving a rental car and your name is not on the agreement, you have committed a crime. So my point is to say this. if you and your state legislatures have or want to criminalize driving a car where your name is not on the rental agreement, a person will no longer have an expectation of privacy, even though the Supreme Court has said that they do in general. So like this is kind of like a magical case. If you want to overturn the Supreme Court essentially in your state, you can do it in this decision, or your legislatures can. So I mean, it seems like kind of an odd case to think about, but like I said, you can all like sort of undo it in your case. So Artis versus the District of Columbia is a case that only a lawyer could love. But it really does impact state legislation, and I actually think your state legislature should do something as a result of this decision. And I have to admit, too, that part of the reason why I like talking about this case is that the court cited the SLC's brief repeatedly, which I'm going to talk about in a second. Okay, so Stephanie Artis worked for the District of Columbia as a health inspector. She brought a federal employment discrimination claim about a year after she was terminated, along with a state discrimination claim, and she brought them both in federal court. The federal court sat on it for literally years. By the time the federal court said, there's no federal claim here, and sent it back to state court, the state statute of limitations had long since expired. So what did she do? She waited 59 days to file in state court. There's a federal statute, it's 29 USC section 1367B that says, statutes of limitations for state law claims pending in federal court can be tolled for a period of 30 days after they are dismissed, unless state law provides for a longer tolling period. So the question was, did she have 30 days after the federal court dismissed her claim to refile, or did she have, plus whatever state law allowed, or did she have whatever time she had when she first filed that restarted again plus 30 days? So the court called this the stop the clock approach versus the grace period approach. The stop the clock approach is when, if your claim expires, the day the federal court dismisses your claim, then you get a new statute of limitations, and that statute of limitations is 30 days, and it's not any longer. Or I'm sorry, that's the grace period. The stop the clock was, oh my goodness, they're all so confusing. All this to say, what the court ultimately ruled was that it's the approach where it's the stop the clock approach, which I explained backwards, which is that on the day that you file in federal court, everything stops. And then when you go back to state court, it restarts, and then you get another 30 days. That was what the court held is the test in this case. They call it the stop the clock approach. And they said it's because the way the word tolled is defined in federal statutes, it's always defined as to suspend or stop temporarily. So the day you file in federal court, your statute of limitations is suspended or stopped temporarily. So the problem for you all from a state legislative perspective is that now, the statute of limitations can essentially be years and years and years for these cases. This woman ultimately would have had about 5 or 6 years to bring her state law claim because as it was waiting in federal court, the statute of limitations was sort of stopped, and then 30 more days was added on after she restarted. So what I would say is this. 32 states add more time onto the 30 days. So here's the thing. Now what you get is you get all the time your statute of limitations was told. Then you get 30 days. Then you get whatever state legislatures add on. And 32 state legislatures add on past the 30 days. So what I would recommend your states do is delete those provisions of statute of limitations that go beyond the 30 days. This is all very complicated and confusing. But if you read the SLC's amicus brief, it'll all become much clearer, I promise. So why I want to tell you about this is that, again, it was in dissent, but Justice Gorsuch cited to the SLC's amicus brief repeatedly. And it was really kind of funny because I know you can't read all this, but basically what he did was he said over and over in his dissenting opinion, like, this is the dumbest thing ever. The National Conference of State Legislatures told us not to do this. They said this is terrible. And he said it 2 or 3 times, like the National Conference of State Legislatures told us not to do this. I thought, Justice Gorsuch, this is a rookie mistake. You don't have to pay nearly this much attention to us. But it was really great to sort of, it was really great to get his sort of like citation. The other thing that was really funny is a guy on Slate wrote an analysis of his dissenting opinion in this case and said it was like one of the worst written things he'd ever read, and that Justice Gorsuch was a terrible writer. And I'm going to tell you guys something. I know this is being recorded, but I don't think Justice Gorsuch is going to see this. I have actually never been able to complete reading his dissenting opinion. It is so complicated and convoluted and difficult. I mean, nothing warms my heart more than him citing to the SLC's brief a couple of times. But I also was completely and totally unable to get through his opinion. Perhaps because like it's just sort of challenging subject matter. But um, but that's the story. Okay, the last case I'm going to talk about is the Sven versus Melvin case. There is no other context other than in front of you guys that I would ever talk about this case. Although I have to tell you this, I get random emails. Like I blog on NCSL, and I'll get random emails about like stuff that I write. And someone did write to me and ask me about this decision, and I was like, wow, someone that actually cares about this case. Um, but this does have impacts on state legislation. It won't change how you write state legislation, but it affects what your state legislation means. So what the court held in this case, 8-1, is that applying Minnesota's revocation on divorce statute to life insurance beneficiary designations made before the statute was enacted does not violate the Constitution's contracts clause. So what happened in this case is a typical soap opera. Mark Spen and Kay Malin married in 97. In 98, Sven purchased life insurance and put Malin, this is his second wife, as his primary beneficiary, and his two daughters from a previous marriage as his contingent beneficiary. In 2002, Minnesota adopted a revocation upon divorce statute that canceled beneficiary designations of a spouse upon divorce. So if you got divorced and you forgot to change your life insurance policy to throw your ex-wife off, the state legislature would do it for you. But the law was passed after they got married and after they purchased their life insurance. You can predict what happened. They divorced. He never changed his he didn't ever change his life insurance policy, and then he died. Who's still on the primary beneficiary? Ex-wife. Who wants the money? Daughters. It's always the same story, right? The children said, look, this revocation on divorce statute canceled ex-wife. Ex-wife says, look, that revocation upon divorce statute, it wasn't even the law of the land when my ex-husband, bought me this life insurance. So that was the conflict. But the contract clause basically says that a state law cannot impair an obligation of contract. And the court said that the contract clause in this case doesn't prevent revocation on divorce law from applying to a pre-existing beneficiary designation. The court basically says, it's an opinion written by Justice Kagan, and she basically says, look, your average Joe does not want his ex-wife on his life insurance policy. And so a revocation upon divorce statute is intended to help all the average Joes, whether they got the life insurance before or after the law was passed. And if your average Joe really wants to keep his ex-wife on his life insurance policy, he can take a whole bunch of very simple steps to make sure that ex-wife is for sure forever on his life insurance policy. And I have the more complicated reasons on the screen. So 26 states, including Minnesota, have adopted revocation on divorce statutes. And like I said, this case doesn't require you to do anything in your work as state legislatures, but it does bar further contract clause challenges to applying revocation on divorce statutes to beneficiary designations that were made before the statute. So it does affect. Okay, so now in my last half an hour, I'm going to transition and talk about sort of what this term means in perspective. Then I'm going to talk about Judge Kavanaugh. And then I have my one slide on what's going to happen next term. So what we saw in this term was that Justice Kennedy really ruled the world. He was in the majority in all the big cases. South Dakota versus Wayfair was his idea, his opinion. In the Kate case, he wrote the opinion. It was his theory of the case that triumphed. And I didn't talk about the partisan gerrymandering case, but I'm just going to mention it briefly. So in the Wisconsin partisan gerrymandering case, there was a majority opinion and dissenting opinion. And Justice Kagan led the dissenting opinion, and Justice Roberts led the majority opinion. And Rick Hasson, who many of you know of, who's sort of like the voice on elections law, said that in that opinion, Roberts and Kagan were fighting for the heart and mind of Justice Kennedy. People cited those two competing opinions as proof that Justice Kennedy was not going to leave the court because it was so clear that he was still going to be engaged in partisan gerrymandering. That ended up not being sort of true. So what we saw for Justice Kennedy this term, who did not join the majority in the partisan gerrymandering case, was he was fairly indecisive and narrow. The Kate case, of course, provides the best example of this. And he probably was this way because And I think he didn't want to leave the court with a lot of messes going forward. Partisan gerrymandering, had he actually ruled to say what Wisconsin was doing was partisan gerrymandering, would have left the court with a hot mess that he would have nothing to do with describing or defining or explaining going forward. The other thing people ask me is, why was he so conservative this term? And my answer is because he is a conservative. He just was an unreliable one, but he was a conservative. But this is the point that I really sort of want to make to you guys. There is a theme throughout this term that is unmistakable in Justice Kennedy's jurisprudence. And mind you, like Justice Kennedy's been on the court for 30 years, and he knew he was leaving. And his theme was this, and his theme is directed towards the people that you work for. In one case, it's directed exactly at them. This theme was simply this. Um, he was really mad about government acting badly. And more specifically about government um, acting in a discriminatory manner, government maybe more specifically um, uh, acting in a discriminatory manner when someone expressed views that the government did not agree with. That is the theme that he had throughout the term. So in the Kate case, you saw that government official, the uh, the Civil Rights Commission, disparaging someone's religion. In the abortion case, the crisis pregnancy clinic case, you saw the state legislature, in the mind at least of Justice Kennedy, of trying to take over an independent organization and force the government's mission on that organization. There was a retaliatory arrest claim that I didn't talk about because it's not very relevant to state legislatures, where the accusation was that a state or a city council had formed a plot to intimidate against a guy that frequently spoke at city council meetings. Justice Kennedy wrote the opinion again and said, cities cannot plot to discriminate against their citizens, particularly at the public comment period, which is the most high-value First Amendment speech that we have in our country. That was another case. And then there was the travel ban. And like I said, I'm not going to talk at length about the travel ban, but the travel ban got a lot of attention because the Supreme Court said in that case that there was no Establishment Clause violation, despite the fact that President Trump and candidate Trump over and over and over again made anti-Muslim statements. And what the court said, and this was not covered well by the news media at all, the court said, this is a national security measure, this is an immigration measure. For those reasons, the combination of national security and immigration, where the president has a ton of authority, we're not going to look at closely at the religious violation or the possible religious violation as we generally would. In other contexts, we would look a lot closer at a possible religious violation, but here, we're just going to apply rational basis. We're going to give a quick look. Is it on its face reasonable? Is it on its face discriminatory? No, it's not, so that's going to be fine. And so that's what the court did. The news media kind of coverage this as the Supreme Court says President Trump can say whatever he wants about people at all times. That's not what the court said. The court said in this more limited or targeted context, the Supreme Court can, not take as hard of a look about religion. So this is how Justice Kennedy responded. And I'm going to read it all to you. And I'm going to say this. This is really important. This is the last thing he said on the Supreme Court. These are literally his last words. They were in a concurring opinion on the travel ban. Nominally, they're geared at President Trump. They're directed directly at President Trump. But if you look at who else he thought was bad actors in the exact same way, state legislature, local government, federal government, all engaging in kind of the same behavior, discriminatory behavior, using power to sort of silence viewpoints that people didn't want to hear, including, like I said, President Trump. So this is what he said. There are numerous instances in which statements and actions of the government officials are not subject to judicial scrutiny or intervention. This does not mean those officials are free to disregard the Constitution and the rights it proclaims and protects. The oath that all officials take to adhere to the Constitution is not confined to those spaces in which the judiciary can correct or even comment upon what those officials say or do. Indeed, the very fact that an official may have broad discretion free from judicial scrutiny, makes it all the more imperative for him to adhere to the Constitution and its meaning and its promise. The First Amendment prohibits the establishment of religion and promises the free exercise of religion. From those safeguards and from the guarantees of free speech, it follows there is freedom of belief and expression. It is urgently necessary that officials adhere to those constitutional guarantees and mandates in all their actions, even in the sphere of foreign affairs. And this is the last bit. An anxious world must know that our government remains committed always to the liberties the Constitution seeks to preserve and protect, so that freedom extends outward and lasts. Isn't that beautiful? How many times have I said this? More times than I almost have it memorized. It still gives me the chills to say that last statement. And like I said, that is geared towards the people you work for. And, he was a remarkable man who had a remarkable career before the Supreme Court. And, it sort of speaks for itself. So what does this term say about our court, our democracy, and the role of Justice Kennedy? Well, the Supreme Court is incredibly powerful. They decide. They pick and choose what they decide, when they decide, and how they decide. They never stop, and they rarely slow down. And they decide many of the most important issues of the day. The Supreme Court is also has the final say on constitutional matters. So maybe more than ever, this week, we should ask ourselves, should it be this way? There are only 9 people. They are not elected. They are appointed for life. They are relatively homogeneous, not average, and never young, though I'm now redefining young. For better or for worse, those qualities make the court nimble, decisive, and skewed. If it has to be this way, I say we were lucky to have Justice Kennedy right where he was. Everyone in this room, no matter what your political views are, agreed with many of his votes. In South Dakota versus Wayfair, we saw his humility and his curiosity. And whether we like it or not, the Supreme Court, as of late, has been our collective voice and conscience. Justice Kennedy made that a moderate, thoughtful, cautious, and open-minded one. And now he is gone. So, where did he provide the critical fifth vote? Anywhere and everywhere. Gun rights, death penalty. Death penalty. I just have to stop because you're like the audience that might be most amenable to me expressing my views on this. This hasn't gotten enough attention. Justice Kennedy and the liberals in the last couple of years have cut back the death penalty significantly. Intellectually disabled, minors. And he didn't do it alone. He couldn't have done it alone. But he was absolutely responsible for that. Affirmative action. So this is the interesting thing about Justice Kennedy. I'd forgotten about this. You remember those University of Michigan cases from the early 2000s? He voted against those. It was O'Connor who provided the fifth vote to say affirmative action is okay in some instances in college. But what he did at the end of his career a couple of years ago is he voted in favor of a Texas affirmative action plan. He was no friend to race-based decision making, but on rare occasions he was okay with it. Abortion kept Roe versus alive in case he did not vote for another abortion. Did not vote against another abortion restriction for a couple of decades. And whole women's health, a couple of years ago, involving a bunch of Texas abortion restrictions, he voted against the abortion restrictions. So abortion here and there. He was the absolute champion on same-sex marriage. If state or local governments won a land use case in the last decade, it was only because Justice Kennedy voted in favor of it. And then, of course, did provide the fifth vote. So where was he liberal? LGBTQ question, the death penalty, race sometimes, abortion sometimes. So now we get to the interesting part of the conversation, Judge Kavanaugh. So what I'm going to talk about, well, I guess I want to back up and say this. I think like a lot of people, I have strong opinions on Judge Kavanaugh and on what happened. And my opinions, I realize, are no better and no more informed than anyone else's. So I will try to limit my opinions, my personal opinions, as much as I can but I will probably share a few of them. But I primarily want to focus on what I really want to talk to you about is what I think his impact on the court will be and has been. But I realize that many of you haven't followed it as close as I have, i.e., you don't type in the name Kavanaugh in your phone every 4 hours to look and see what the new news stories are. So I'm just going to go over very quickly some of the background. And it's hard to sort of cut back everything I could possibly say. But what I'm going to cover is what happened, how people reacted to the hearing, what happened with the investigation, where we're at right now. I'm going to talk about the national reckoning I think we're having with sexual assault, what this means for the court, and I guess, how Justice Kavanaugh is likely to vote on the court. So what happened is basically this. He went through his regular hearings, and then 3 women came forward with allegations of sexual assault and or inappropriate sexual behavior on the part of Judge Kavanaugh. The first one was Dr. Christine Blassie Ford, who claimed that in high school, she was at a party, and Judge Kavanaugh, in the company of a friend named Mark Judge, uh, uh, touched her in a sexual manner and prevented her from leaving. She was ultimately able to leave the situation, and the sexual assault went no further than that. Those were her allegations. Deborah Ramirez said that at a party in a dorm in Yale, Justice Kavanaugh exposed himself to her. Swetnick had a myriad of allegations that were a little more vague in regards to Justice Kavanaugh. They involved him being at a party where men were spiking drinks and gang rapes were happening. So those were the three allegations. The Senate did a hearing of the Ford allegations, and then the Senate held a hearing in which Ford and Kavanaugh testified, but the third person allegedly in the room, Mark Judge, did not testify. So how did people react to the hearing? This is a poll from NPR, PBS News, and the Marxist poll, or the Marxist poll. So 45% of people thought that Ford was telling the truth. 33% thought Kavanaugh was telling the truth. There was a fairly significant gender gap, but the most significant gap by far was based on partisan politics. Interestingly, more Democratic men believed or Dr. Ford than Democratic women, at least in this poll. What I thought was sort of interesting was that this poll did not seem to ask about, but another poll did, if people believed both. And the other poll that I saw in a Huffington Post story said that most people did not believe both, which really surprises me because almost everyone that I've talked to since the hearing, with the exception of a couple of people, myself included, overall believe both. But the belief in terms of Judge Kavanaugh was that was too drunk to basically remember what he did in those instances. But that's sort of how people reacted to the poll. And regardless, more than half Americans are not in favor of his nomination going forward, are not in favor of him being a Supreme Court justice. Um, so in terms of explaining how people reacted to the testimony and why maybe they had the impressions they did, the Mitchell report came out. This is the prosecutor or the attorney that the senators hired to sort of ask questions of Judge Kavanaugh. So she highlighted some troubles that Dr. Ford had, namely that there were gaps in her memory and that there was no corroboration. For example, Mark Judge said that he didn't remember this happening. And then how many people have seen the Saturday Night Live skit? Okay, if you haven't seen it, you guys have really seen it. Those were a lot of hands. The Saturday Night Live skit highlights the problems with Judge Kavanaugh. He is perceived as angry, entitled, very, very partisan, and deceptive. I would say there's a huge gender gap over the anger. Jeff Flake, I saw Jeff Flake talking about it, and he said, look, if I was wrongly accused of sexual assault, I think I would be that angry. Women, on the other hand, say, if I ever in any context was that angry, I would be labeled crazy and irrelevant. So that's, I think, where the gender gap sort of comes down on that. In a totally unexpected and kind of unprecedented move, Jeff Flake requested an FBI investigation, which is what happened over the last week. For those of you who haven't read the James Comey book, I highly recommend it. It's so interesting on so many levels. What he said basically was like, look, if this is an investigation to get the truth, there wouldn't be a limit, because there was a limit on how long the investigation could be, just 1 week. And we would have had an investigation a whole long time ago, way before we did. And he said, you know, the Republicans, what they want out of this is to say that there was no corroboration. What the Democrats hope for is that there is incriminating evidence that derails the nomination. So a lot of questions were raised about the investigation. Who was in charge of defining the scope of it? Sometimes it seemed like the president was saying it was going to be very narrow. Then he said the FBI could do whatever they want. And there were basically three questions raised about the breadth of the investigation. Would all three accusers be questioned? Then what about the other witnesses? Demi Ramirez said, I have 20 people who either saw the incident and or could provide relevant information, whatever that information might be. That was another question. And then would Judge Kavanaugh's, supposed lying about drinking, about his yearbook said, would all that be explored as part of the investigation? Those are the big questions. Then the question was, how would the results be delivered? And we all know the answer, in the most bizarre way possible. It would be all locked in a room, and senators could read it like one at a time for an hour. And then another big question that came up, I think is very relevant, was how should these allegations have been handled? The Republicans were very angry about Dianne Feinstein holding on to these allegations for a long time, and I even read in Politico a criticism of that. But the theory is sort of this. Had Dianne Feinstein immediately gone to the FBI and said, I have a woman, she wants a confidential investigation, what Feinstein could then have done is gone to Chuck Grassley and say, look, your buddy Kavanaugh, we've got an investigation against him, so why don't you nominate someone else? And then none of the things would have transpired later. So in the backdrop was the question of like, how should these allegations have been treated anyway? And in the actual hearing, it was sort of interesting. You have a senator asking Feinstein like, "Did you leak these?" And she's like, "No." And then he's like, "Well, did your staff leak it?" And she's like, "I didn't ask them." And then, no, my staff said I already asked her, and no, she didn't leak it. That had a Saturday Night Live moment in and of itself. But I think Anita Hill's point is well taken, which is that no matter what you say about what Dianne Feinstein did, there still is no process for dealing with sexual harassment or sexual assault allegations. And this process clearly illustrated that. So when the investigation results came out, I guess a summary of them came out yesterday, and the Republican reaction was the investigation was very thorough, and there was no corroboration of any of the charges. Democrat reaction could not have been more different. Many people were not talked to. Julie Swenwick was not talked to at all. I think many, if not most, of the people that Deborah Ramirez had pointed to were not talked to. And I don't think there was much exploration done at all about Kavanaugh possibly lying about the drinking and the yearbook in the investigation. So again, like I haven't seen the investigation, and no one has except the senators. So it's a little unclear about what exactly, but those were the overall reactions. A great article on CNN about what was Jeff Flake really looking for. I mean, the writer basically said, in terms of like literal corroboration, like that probably wasn't a realistic outcome from the process. In the meantime, while the investigation was happening, some tarnishing evidence came out about Ford, kind of small stuff like maybe she had helped someone prepare a polygraph. I wonder a little bit about that. I've had two people go through polygraphs that have asked me about them. I can't say I helped them, and she said in her testimony she'd never helped anyone. So other information came out about the credibility of Swetnick. And another interesting thing that came out was there seemed to be some evidence that Judge Kavanaugh knew about the Ramirez allegations as early as June or July, and that his people were trying to mitigate them at that point in time. And then of course the infamous bar fight that Judge Kavanaugh had apparently thrown ice at someone that led to a bar fight. I thought, I don't want to know if anyone has been in a bar fight in college, but anyway. Probably the three most interesting and powerful statements that came out during the week when there was the investigation was, first of all, from Justice Stevens. He's 98 years old, a longtime Republican. As far as I know, this is probably inaccurate. Only twice since he's left the bench has he made some really public statements that I'm aware of that have gotten national media attention. One was he said he thinks the Second Amendment should be amended after, I think, one of the shootings. He said, no, it's been interpreted wrongly. It needs to be amended. And I think that was like a Washington Post op-ed. And then Justice Stevens said that the partisan remarks that Judge Kavanaugh made during his statement should disqualify him from being on the Supreme Court. The article that probably friends and people I don't even know sent me the most often was, I know Brett Kavanaugh, but I would not confirm him. How many of you read this one? Okay, yeah, I mean, a good many of you have read it. So this guy is someone who's like, look, I like Brett Kavanaugh. I know him pretty well. I like his politics. I'm not afraid of him being a conservative. The question for this author was, he said, after he made all those partisan remarks that he made at the hearing, could this is how he frames it, a reasonable pro-choice woman feel that if a challenge to Roe versus Wade went in front of the court, that he would be objective? And this guy concluded, no. And then, I mean, a couple of Judge Kavanaugh's drinking buddies, right before yesterday, did an op-ed, I think, in the Post saying, we drank with Judge Kavanaugh. We were friends with him. We like him. He blacked out all the time. or we believe he drank to that point frequently, and we know because we were literally doing it at the same time. Judge Kavanaugh, seeing the criticism, particularly about the partisan remarks that he made at the confirmation hearing, also wrote a nice response in the Wall Street Journal to those criticisms saying, look, I promise I'll be fair and impartial. So where are we at right now? The final vote will take place today. I don't even know what time. Unless something completely unexpected happens, Judge Kavanaugh will get the votes. And it's important to remember that we had changed the process. Before this nomination of Judge Gorsuch, we would have needed 60 votes, and there's no way Justice Gorsuch should have, or Justice Kavanaugh would have gotten through under that standard. Um, the only real winner, I think, in all of this, and there is a winner. There is a winner. The winner is partisan politics. That's who succeeded. The optimist in me wants to say that had this happened 6 months ago, when the Republicans didn't feel pressured to get someone through because of the midterms, if this would have happened 6 months ago, that there might have been a different outcome. That some of the Republican senators would have said, this is too much for me. I can't go forward with this. And maybe some of the Democratic senators would say, look, I believe him. I don't believe her. I'm voting for him. That's the optimistic part of me, the part of me that like is very hopeful. But the more cynical part of me is like, yep, there was a winner, and it was partisan politics. So what are we going through, I think, as a country is sort of worth talking about. I have a friend who is a therapist, and she said to me last week that every single one of her clients wanted to talk about Brett Kavanaugh, no matter what their issues were. It was Brett Kavanaugh all the time in therapy last week. And she said to me, I don't understand. She's like, there was Bill Cosby, there was Harvey Weinstein. I said, this is totally different. And I think the reason why it's different is that, roofies is its own sort of class of strangeness. I certainly know people who were given roofies, but it is a niche sort of thing. Harvey Weinstein was just a prolific monster. Moreover, he was a Hollywood mogul, and he was preying on Hollywood's elite. It's hard for me to relate to that. So what, Dr. Ford said was that all that she did was she went to a party. That's all she did. And I said, and I think that like going back to my high school English class, so a tragedy is pity and fear for one like yourself. It's easy to put yourself, I think, in the shoes of Dr. Ford, whether you're a man or a woman, because you've been to a party, and I think that was part of the reason why this was sort of different. But I think the other thing was just having to watch her testimony. 20 million Americans watched it, and it wasn't sexual harassment; it was sexual assault. And I think what we all sort of went through as a country, those of us who watched it or listened to it, was that we realized how often this happens. I mean, the statistics have been said over and over again, and everyone agrees that those statistics are low. And we realize how we don't talk about sexual assault. And I think we also realize how ugly it looks when we actually do talk about it. And we have to hear how bad it is and how it caused some, woman to have two front doors. So I think that's the national reckoning that we're going through, and that's what we're thinking about. I encourage all of you to have a personal reckoning on sexual assault. This is a complete coincidence. I'm not lying or making this up or even exaggerating the time frame. It just happened to be that about 2 weeks ago, I finished reading this book called Missoula, Rape and the Justice System in a College Town. And how many of you have read Into the Wild? Or Hands Up High? Okay, so I've asked this now at like 4 seminars, and it's my belief that in any educated crowd, a fourth of people would raise their hands. I actually thought you guys would be higher. You were a little bit higher than all my other audiences because you're like, you're kind of nerdy and thinky, you know what I'm saying? So Into the Wild is it's an iconic book. Many people have read it. It's about this guy that goes to Alaska, and he dies probably because he ate some berries he shouldn't have eaten. He could have easily left, but he didn't know the way out. And he kind of wanted to be this stereotypical, like, American independent person, but he didn't quite know what he was doing. It's a remarkable book. John Cocker has written a bunch of books. And one of them was this Missoula book, which I just happened to have picked up about a month ago. Every question you have about sexual assault, everything you've ever wondered about it is in this book. It's written for anyone that could understand it, anyone could appreciate it. I think of myself as a grizzled person. Nothing can surprise me. I barely could make it through this book. The book is simply shocking. But I think, and I think there's people that think, well, I don't know anyone who's sexually assaulted. I would never sexually assault someone. I would never be sexually assaulted at this point in my life. You know someone who's sexually assaulted. You know many people who are sexually assaulted. And I think like this book is just it's a remarkable book to sort of explain and understand the phenomena. It doesn't shed any light on what really happened in these particular instances, but it really tells a story that I think um, all Americans should be aware of. But now the part that I guess I really want to talk about is what are the impacts on the Supreme Court for what happened. And I mean, you probably don't need me to tell you that this is terrible for the United States Supreme Court. It's hard for me to believe that something this bad could even happen. Um, and what makes it really terrible is this. The Supreme Court, as we know, is not supposed to be a political body. It's supposed to be a body focused on justice, objectivity, fairness, and the law. And here we have Judge Kavanaugh, not just another justice. He's someone who is unapologetically conservative, who's replacing a moderate justice. So I didn't go into a lot of detail because I assume you're all fairly familiar with this, but um, Justice Kavanaugh, Judge Kavanaugh, made a number of partisan remarks in his 45-minute testimony that were truly stunning. I would say my jaw hit the floor when I heard him, and they kept on coming out. And I think the other thing that may be surprising about it is the remarks are really obvious. I mean, it's not like I disagreed necessarily with his remarks. I mean, other people could have made those remarks for him, and he wouldn't have had to get himself into trouble. Maybe not all of them, but I was shocked by him saying, like I said, such partisan things when he knows, that the court is supposed to be a nonpartisan institution, and that, like I said, like they were so obvious. And these remarks come from a deeply partisan person, which I'll talk a little bit more in a second. And whether or not he makes it on the court, and he will, at this point, the court is going to look more partisan. And I would say this too, the court has done a lot of things over the years, since the beginning of time, that really upset people. Just think about in a couple of recent years, the Affordable Care Act decision made people livid. The same-sex marriage decision made people livid. Justice Ginsburg's remarks about President Trump made people livid. But what's different between that and now? The court was actually doing something. Here, you have the court sitting around doing nothing. And this sort of trial has been brought to its door. So who is Judge Kavanaugh in terms of his jurisprudence? We only really know three things about him for sure. He's very conservative. He could be more conservative. He's been put by the statistician somewhere between Thomas and Gorsuch and Alito. He has very solid views on administrative law on the D.C. Circuit. That's about all you write about. And he hasn't ruled on a lot of issues relevant to state and local government. Why? He's on the D.C. Circuit. There's only one local or state government he would hear cases from. It's D.C. So we just don't know a lot of his views. From what we've seen from his decisions so far, he'll be a standard, conservative, standard sort of hardline conservative. Maybe have a harder line. We can guess that he'll be pro-property rights, pro-religion in public spaces, anti-race-based decision, even if he hasn't made a lot of decisions sort of in that space. So for those of you who are uncomfortable with left-wing conspiracy theories, I do encourage you to cover your ears. But I heard this, so I'm not claiming it's my own thoughts. I heard this from at a liberal sort of presentation. But it is something sort of interesting to think about, which is why was Judge Kavanaugh the one? Why did President Trump appoint him and then stick so closely and carefully with him? So this is the deal. Remember, President Trump had a first list of possible Supreme Court justices, a second list, and a third list, right? So Kavanaugh wasn't on the first list, he wasn't on the second list. Why was he not on those two lists? Pretty obvious answer. He had a long partisan background. He'd been involved in many controversial things and was a firmly established Republican operative. And so I think that's why he didn't make the first two lists. Now, this is where the conspiracy goes. Why did he make the third list? What changed between the second and the third list? These are the two things that changed. The first is the Mueller investigation. Judge Kavanaugh has written extensively in the Minnesota Law Review about his views on the fact that he thinks the president cannot be indicted and tried while in office. Very few lawyers have written on presidential authority. I mean, I haven't written on it. And so President Trump saw in him a real advocate. The other thing, too, was the D.C. Circuit heard an abortion case. It involved a young girl who was pregnant, who was undocumented, who wanted an abortion. The D.C. Circuit said, we want to appoint like an adult, a sort of foster parent, to help you make the decision. And Judge Kavanaugh agreed with that, but that's not what ultimately happened in the case. Judge Kavanaugh used the word abortion on demand in that opinion, which I guess is loaded language, but more importantly, perhaps, he called Roe existing precedent. And people say if you say this is my existing spouse, your existing spouse should check the life insurance policy, right? So I think and this is again just sort of my own personal opinion of what I think should have happened in this case, and I have to wonder a little bit about it, is that I think he was President Trump, I think, stuck his teeth into this candidate, in part out of stubbornness, but in part because this guy, could really deliver on some important things to him. And so the last point I'll make about Judge Kavanaugh is Justice Kavanaugh is that remember it's not just how he votes that will make a decision, make a difference. It's what petitions he wants the court to hear. So remember, the Supreme Court only hears petitions when they get 4 votes. Most people believe, including myself, that the reason the court hasn't heard a gun case in a decade is that Justices Kennedy and Justice Roberts would not provide the 4th vote to grant a petition. If the court took a gun case, I think Justices Alito, Justice Thomas, Justice Kennedy, and Justice Roberts all would have been pro or anti-restricting, gun ownership. But the court didn't take those cases because no one would provide the 5th vote. I think what we're going to see happen is Kavanaugh's going to come in. He's going to be more inclined to provide the 4th vote, to accept cases where Roberts and Kennedy are uninclined to do so. And then Roberts has a choice. What will be happening is that you'll see Kavanaugh trying to sort of push the hand of Justice Roberts. And Justice Roberts is going to have to decide which way is he going to go in some of these cases that he'd prefer the court not to hear, where he has a conservative leaning, but maybe, wouldn't think that it was in the best interest of the country to go a certain way. So in terms of a preview over my time, but Kate told me I could take a couple more minutes. I'm just going to say I'm going to say only 2 things, and that is this. The Supreme Court has accepted a bunch of cases involving states, more than usual, in fact. There are no blockbusters. There's nothing that's a really sort of huge deal. But the first 3 cases that I have listed on the screen are very interesting because they all involve the question of whether the Supreme Court should overturn precedent. This Supreme Court does not overturn precedent. So it is kind of remarkable that the court would take 3 cases on that question. All 3 of those cases directly impact the states. The second and the third more than the first. And the last thing I'm going to say is the court just took a case involving alcohol. 21 states have durational residency requirements on alcohol. So if you want to sell alcohol in a state as a retailer, you have to live in the state for, let's say, 2 years. There are also other residency requirements that state laws impose. Those may be struck down as unconstitutional under the Dormant Commerce Clause, so that could affect a number of your states. So with that, I am 6 minutes over. Thank you so much for your time and attention. I wish I would have had more time for the preview. I hope I didn't offend any of you about my discussion on Judge Kavanaugh, soon to be Justice Kavanaugh, and enjoy the rest of the conference.